From the minutes, item number 1.
My Lord, before my Lord takes up the thing, I beg to seek permissions from my Lord. We are just a concerned people from South Garo Hills, my Lord. Now we know that...
I've seen you staying only in East Khasi Hills.
My Lord, my clients, I mean to say, my Lord, the people. My Lord, so we know that, my Lord, the coal mining has been banned by the NGT and also by the Supreme Court. And now, my Lord, is also concerned about this, the illegal coal mining that's been going on.
We're not doing anything new.
My Lord,
we are just
exactly.
implementing the ban which is there in place.
Yes, my Lord. So, my Lord, just to assist my Lords, now what is happening, my Lord, is that in spite of so many directions, my Lord, in our area, this coal mining is going on with impunity, my Lord. And we have, in fact, written to DP, but I must say very with fairness that I have no interest whatsoever. We are just concerned that the manner in which the orders of the courts have been flouted with impunity, my Lord. This is so, we want to bring some photographs, my Lord.
But that is what makes life exciting, does it not?
My Lord.
Court passes orders, people don't follow it. That's what makes life exciting.
My Lord. And what is happening, my Lord, the coals are coming from West Khasi Hills, going through the jungle road. There is a check gate, my Lord. Police are allowing to pass through.
What is the rate?
My Lord, they are saying that 300 rupees, something like that, my Lord, per truck. My Lord. But then again, my Lord, that goes because they will be down.
You give us how far up does it travel?
My Lord, my Lord.
Give us details of how far up does it travel?
My Lord, allow me to file an IA, my Lord. I will come with details, my Lord.
You file an IA, we'll look at it. These are suo motu proceedings, there are other proceedings.
My Lord.
File an IA, whatever.
My Lord.
Yes.
Obliged.
Mr. Khan, where are we?
May it please, Your Lordship. Lordship, as per
we are at a stage where you say that, so what if you are passing orders?
No, absolutely not, Your Lordship. Lordship, as per the order dated 15/5/2023, especially...
It's very difficult to see your sad face. In other matters, you're brimming. In this matter,
it's a most unenviable...
hide behind the chair.
Lordship, it's an unenviable position any government lawyer can be in this case, Lordship.
And of
but
your own
having
doing.
said that...
Of your own doing.
Absolutely, Lordship. We are trying to do the damage control, Lordship. Lordship, as per the order dated 15/5...
Where are those reports by the
Lordship, yes.
Chief Secretary and the DGP?
Lordship, we have filed the Chief Secretary's affidavit. So far the DGP is concerned, Lordship, there has been slightly inadvertent error in the last paragraph and the registry has not accepted it. So, Lordship, this matter can come up.
It's not affirmed. It's not verified.
Absolutely, Lordship. So,
which is true to knowledge and which is...
Absolutely, Lordship. So, there was slightly a glitch on that part. We're trying to rectify it today itself. If the matter can come up or two, or if not tomorrow itself, Lordship.
We'll keep it next week. And where are we as far as the report is concerned? The last interim report?
13 report, Your Lordship, was very damaging, Your Lordship. So
scathing?
Absolutely.
Yes, Dr. Rosiga?
I have no instructions for it.
Very well.
That was what?
Oh, yeah.
And Lordship, we have taken actions on the 13 report which was highlighted by the court.
What we'll do is we'll keep it on Thursday because my brother is not going to be there for some time. He's going on an official
day after tomorrow
assignment. So
day after tomorrow.
We'll keep it on Thursday. Do it and also tell us what your police is doing. As we told you that, as the Meghalaya High Court, it gives us no pride or pleasure in seeking outside forces.
Absolutely.
Because we should be able to manage our own affairs. And it's out of desperation that we seek outside assistance. And most probably we are going to direct the central agencies to deploy force over here. We don't wait for their permission or anything. Our order is subject to appeal. They can go take it wherever it needs correction.
But the last communication I received is they're trying to file an SLP against the previous orders.
We are not waiting. We had, by way of courtesy, asked you so that your logistics would have been easier. Now we'll direct you within 24 hours you do it, or else we'll pull you up till our order is stayed. So put them on notice.
Well,
Now we'll not care for your convenience or anything.
well.
Day after tomorrow.
Since the state seeks some time, particularly to file the report by way of an affidavit sought from the Director General of Police, let the matter appear on Thursday's date.
Oblige.
I'll-
I'll send to the sir.
Any mention for unlisted matter? Any mention for unlisted matter? From supplementary list, item number 1.
At the end of the board.
Lordship.
Item number 2, item number 6.
May I please, Lordship? Lordship, after going through the provisions and all, it is found that the appeal does not lie, but the relief lies in 397. So the appeal has to be.
You to withdraw with remand to file.
Lordship.
Since the appellant since the applicant accepts that the proposed appeal would not lie, in view of section 375 of the Code of Criminal Procedure 1973, the application is permitted to be withdrawn without going into the merits thereof. Paragraph, this order will not prevent the applicant from pursuing any other remedy in respect of the matters complained of in accordance with law. Both so and so and so and so are disposed of accordingly.
From the main list, item number 1.
Yes, sir.
Lordship, this is a contempt petition for disobedience of Lordship's orders dated 14th December 22.
Yes.
Lordship, straight away, page 34 is the order. There was a time.
Are all the respondents represented?
Yes, Your Lordship.
Yes.
Very present.
Why has that order not been complied with, Mr. Thapa?
My lord, here the order was taken to Supreme Court, my lord. The order was assailed before the
Unless there
Supreme
is a
Court.
stay,
My lord, there was some modification, my lord.
unless there is a stay, you can't think. File an affidavit and indicate. The alleged contempt laws should file an affidavit.
My lord, I'm sorry, my lord, the affidavit has been filed already. My lord, bring on record the Honorable Apex Court's order, my lord.
Where is the order?
They were supposed to file rejoinder to it, my lord. And in terms of the Honorable Apex Court order, my lord, we had also made a proposal to them.
Where is the stay? Show us the stay.
Your Lordship will find at page 5, annexure 1
Page 5.
of my affidavit, my lord.
We do not find it a fit case to interfere.
Yes, Your Lordship. But
However, this will
however,
not preclude the petitioner from submit a fresh proposal. Then
we have made a proposal to them, my lord.
So?
As a matter of fact, they, on the last
you make a
occasion,
proposal that does not.
my lord, they had sought.
The SLP was disposed of.
Yes, Your Lordship.
Yes, Your Lordship.
Very good. The respondents rely on an order dated March 2023 passed by the Supreme Court on a petition for special leave to appeal arising out of an order of this court passed on December 14, 2022. Full stop. Paragraph. It is evident from the relevant order that the Supreme Court was not inclined to interfere with the order impugned before it, but gave liberty to the petitioner before it to submit a fresh proposal to the respondent corporation. Full stop. The further observation in the order of March 20, 2023 is that upon the revised proposal being submitted, the same would be objectively considered by the corporation. Full stop. The special leave petition was, accordingly, disposed of. paragraph. The respondents say that a revised proposal has been made when?
It was on 17/4/2023.
On April 17, 2023, full stop. The petitioner herein will objectively consider such proposal, uninfluenced by any observation in this court's previous order of December 14, 2022, and communicate its reasoned response to the respondents within a fortnight from date. The matter will appear 4 weeks hence.
Deeply obliged.
Lordship, I may only point out that that aspect has been done, and the proposal was considered. Certain time was granted. They are in breach of that also.
Very well.
So therefore, today,
Very well. They've just bought time. They've bought time. They've bought time, and anyway, a paragraph it is submitted on behalf of the petitioner that the proposal has already been rejected. Full stop. Since the proposal was required to be considered objectively, hopefully reasons have been furnished for its rejection. Full stop. The proposal and the rejection thereof shall be brought on record by way of a supplementary affidavit to be filed by the petitioner for the matter to be considered thereupon.
Lordship,
Deeply obliged.
Yes.
I'm okay.
Item number 2.
Let me connect. See. Now, in this matter, the issue is still pending before the Honorable Supreme Court, Monitor.
It's still pending?
Yes, ma'am.
Since the legal issue is still pending before a 9-judge bench of the Supreme Court, let this matter stand over for a further period of 3 months. Paragraph, the parties will have liberty to mention for an early listing immediately upon the earlier disposal of the Supreme Court case. Yes.
Obliged.
Item number 3.
So you're staying back?
Lord, yes, I have adjusted my plan. Lord, I'll be able to assist your lordships physically tomorrow, Lord.
Thank you.
I'm so deeply blessed.
Because unlike as previously thought,
Yes,
you have to answer.
yes, my Lord, I appreciate that. I'll answer that.
It's not as if that no answer is called for.
Yes.
So you just briefly recount what you've covered, the area that you've covered, so that if we've missed anything, you can correct us. You basically yesterday dealt with two overarching considerations. One is of both the references for all intents and purposes being required to go to the same place. We'll deal with that. You've concluded. You also took a ground of bias, which you'll elaborate on at your convenience. And then, on a point of principle, you referred to Kochi cricket to say that, notwithstanding prior commencement of arbitration proceedings, you are entitled by virtue of Kochi cricket and HCC to take advantage of the amendment subsequently. Then you have taken 7 grounds. Of the 7 grounds, the first is interest, the second is delay in explosives, supply of explosives, the third is delay and short supply of cement and steel, the fourth is rock strata, the fifth is tunnel collapse, or rather the fourth is tunnel collapse, the fifth is rock strata, and there are 2 others. You have covered up to tunnel collapse, and the remaining 3 are there. And your main grounds are in respect of the first 3, where you have made 2 legal grounds. One is that you've said that there are express clauses in the contract, and you've demonstrated clause 55 for interest, and for that purpose you relied on Jayaprakash, which had the similar or in respect of any other matter whatsoever. So those were the last. I may be wrong in quoting it, but it was paramateria with clause 51 of the reported judgment in Jayaprakash. That is one. The second is, you say that even if there may not be any express in respect of some of the others, like delay in explosives and delay in supply of cement, you relied on 2 clauses, identical clauses from the general conditions and from the supplementary, and you've said that the word not, which is missing, must be read into that, otherwise it does not make any sense. And by relying on those, you say that both of them are expressly prohibited. Your further limb of argument, which you've made but which you have not yet made good, is that there could also be implied terms which would prohibit the arbitrator from going, but you have not demonstrated that yet in respect of the areas that you have covered. The further point that you've made is that since you're entitled to 34(2) capital A, you referred to the case between the same parties, which also recognizes Section 26 of the Amending Act to have been overridden, as to what would amount to patent illegality. And according to you, patent illegality would be within the meaning of that expression in the relevant provision, when the view taken is not a possible view, or when the arbitrator wanders from the agreement, which is the entire area of his. And you also make a very interesting point on an extension to patent illegality, and or at least that is what we've surmised from your argument, which is that because of 31(3), reasons have to be given. There can be overarching reasons given which will cover the entire gamut of disputes, of claims. Say, for instance, there's been delay all around, and there's a finding rendered on delay. So therefore, on various heads for delay, no independent reasons have to be proffered. But when independent heads of claim are being dealt with separately and distinctly, then reasons in support of such independent heads have to be given, and the mandate of 31(3) must be read to be so. And you referred to, at least in case of head of claim 2 and 3, which is your delay in explosives, supply of explosives, and delay and short supply of cement and steel, that the objections recorded at pages 70, 71 or thereabouts were not dealt with in the findings between pages 90 and 95 or thereabouts. And in any event, not only have they not been dealt with, no independent reason has been given as to why they were satisfied that the heads of claim, to the extent allowed, were justified. So that in a nutshell has been your submission yesterday. We have two questions before you start. What is the total quantum of award?
Yeah. Now, in lot 1, the total quantum would come to about 100 crores.
All the 5 together?
No, only lot 1.
Only lot 1.
If your lordship sees 780, your lordship gets 780 of the appeal paper book.
Yes.
Your lordship will get the aggregated claims.
Because I was searching for that, didn't find it.
Yes.
Mr. Dholakia, this is also for your benefit.
My lord, I'm most obliged to my lord.
In fact, we'll circulate the judgment that I have prepared already. So both of you can go through it and then give it back to us.
Certainly. Be most instructive, I'm sure. Grateful.
At 780
780
of the appeal paper book, your lordship has that.
Yes. Lot 1, total award is
9316.
It's in lakhs.
So it would be, yes, 93 crores.
93 crore. Lot 2 is 57 crore.
Yes.
Lot 3 is 10 crore.
And the road works over the page, Madam.
Road works rejected.
No, Madam. There is an amount
Oh,
awarded.
there's an amount. Yes. Amount awarded.
10 lakhs 3,142 and 10 lakhs
Yes.
3,000.
10 lakh and 10 lakh in both cases. Identical amounts. One is 17.60 kilometers, one is 13 kilometers, and in both cases, you got
The award is
They've not calculated
No.
the interest. They've not calculated.
different amounts. Interest is the same,
yes.
but the amount is 1 crore 59 in one and 1 crore 1 in the others.
No, this is amount claimed, amount awarded, interest not calculated.
The amount awarded, my lord, is on the right hand column, where your lordship gets the figure.
Middle column 1.59
That's correct.
and 1.01.
Yes. And then 10 lakhs is
Those are the interest.
the interest.
The interest here is not calculated.
Yeah.
And therefore, the total award in this case is 132, and total award in that case is 190.
Interest is not calculated. And this road is a petitioner's expense.
No, that's amount claimed.
No, see total award.
Yeah,
Yeah, my lord. The fourth column.
No,
fourth row.
Fourth row, my lord. 159, 84, 082.
yes.
Then below that, interest on the petitioner's share of expenses.
Maybe a deduction.
So that will be 159 plus 10, and this will be 101 plus 10.
Yes, my lord. To be fair, my lords, I am not very sure what this amount of 10,03,142 is. Probably, my lords, that amount is deducted. I am not very sure, my lords.
Deducted.
Yes, because it is the interest on the petitioner's share of expenses.
So where is the final figure?
The final figure, unfortunately, my lords, is not really stated, because even the applicable rate of interest is not calculated. It's not aggregated in the award.
Unlike the
unlike the other claims.
So what happens is that even if just interest were to go, it would be reduced to roughly 20%.
Yes, it would substantially reduce, because the interest part of the claim.
Yes, if you see the interest part is 31 crore becomes 93 crore, 1900 crore becomes 57, exactly triple.
That's correct.
Exactly triple. So 30% of the award would be remaining.
Lordship, please.
Yes.
May it please, Your Lordship. Thus, carrying on in the same vein in which I had made my submissions yesterday, my lords, the next head of claim, my lords, is with regard to the extraction of boulders.
Yes. Rock strata deviation also you've completed.
That's correct, my lords. Rock strata deviation, my lords, under two heads I have covered, my lords. One is express bar, and I'm relying on 3.10.1. And the second, my lords,
6.6 read with 7.
Read with 7. And according to me, my lords, 6.6 read with 7 also mirror the same thing that is said in 3.10.1 in my respectful submission.
Next, you'll do extraction of boulders.
Lordship, please. Now, in so far as that aspect is concerned, my contention.
Just once.
Lordship, please. Give me my award.
Yes.
My contention before the learned arbitrators, my lords, is at page 72. The finding is at page 102 and 103.
Yes, sir.
And, my lord,
72.
Lordship, please. Before
What
I
is
take.
your contention?
Yes, my lord. 72 is my contention. The findings, actually, my learned junior rightly corrects me, my lords, starts from 101 to 103. The relevant clause, my lords, is clause 13.
Yes.
So before going to the findings, I may just invite your lordship's kind attention to clause 13.
That's part of Annexure C.
That's part of Appendix A, my lords.
Appendix A.
Your lordship gets that. At page 49.
Yes.
Clause 13. May I read that, ma'am? The corporation will assist the contractor for obtaining permission to operate quarries for stone, bar, sand, procurement of construction materials, other than those issued by the corporation for this work, as per relevant clauses of the bid document, shall be the responsibility of the contractor. Procedure for issuance of store material shall, however, be tied up separately, and the contractor shall strictly adhere to such procedures. Now, my respectful submission is that the only responsibility on us was to assist in him procuring the permission, because in order to mine out these quarries, he would have to get permission from the government. Now, there is no finding of the learned arbitrators that such assistance was not rendered. The finding is that there was administrative delay in getting the requisite permissions. And it is on that basis that I have been held responsible for the delay, and for that particular period I have been cased with damages. May I just show your Lordship the relevant finding in this regard? The contention your Lordship will get at page 72. Your Lordship sees small Roman 8 at the top. As regards have your Lordships got it? As regards the issue of permission for extraction of boulders, bar, sand from Assam river quarries, the respondent averred as follows. The respondent denied the allegation of the claimant that the respondent could not obtain administrative order for extraction of bulk quantities of boulders and sand from concerned authorities in Assam, and the same being the cause of delay, and also denied the averments and submissions made by the claimant. The respondent referred to the provisions of clause 13 of the detailed work order, which stated that the respondent would assist the claimant for the said permissions, and that the responsibility of procurement other than department issued material rests with the claimant. The respondent informed that it had endeavored and obtained necessary permission for initial operation, and hence allegation of claimant cannot be agreed. The respondent stated that the allegations were being made by the claimant to shirk off its own prime responsibility in execution of the work as per the provisions of the contract. Now, the finding in this regard, your Lordship will get at page 101. Your Lordship just sees the foot of the page at 101 under G, permission for extraction of boulders from Assam river quarries. May I read that? The arbitral tribunal has gone through the submissions of both the claimant and the respondent in this regard. The Honorable Chief Minister Mizoram requested the Honorable Chief Minister Assam to grant permission for extraction and transportation of boulders and sand from Assam to Mizoram. The same was granted, and the respondent was advised to take necessary administrative order for the same from the Chief Conservator of Forest of Assam, who allowed the claimant to extract 12,000 COM of boulders on an ad hoc basis on the issue of the said permission, pending completion of formalities pertaining to administrative order, and this was meager compared to the requirement of stone aggregates and the sand for the work of the diversion tunnels alone. The arbitral tribunal notes that the claimant had required the respondent to obtain the permit for collection of 136,000 COM of boulders for Turial project works for the financial year 2003-2004 from competent authority in Assam. The Assam Forest Department issued permit for collection of another 10,000 COM of boulders and 3,000 COM of sand on 17th March 2004 against the above requirement. But the respondent could not obtain the administrative order for extraction of bulk quantities of boulders and sand from the said authorities in Assam for the said period. As a consequence to the above, Forest Department Assam did not allow the claimant to extract further boulders from Assam river quarries for Turial project works. The AT notes that in the meeting held between the respondent and the claimant.
Gone through, Mr. Amity.
Lordship, please.
Now, in respect of these matters, both on account of short supply of explosives, one is the finding. With or without reasons, let's forget it. One is the finding. Where is the quantification?
Yes.
Where is the quantification of the claim?
Yeah. Now,
Because
yes,
these are all in the nature of damages.
Lordship, please.
And as you know, in damages, first there has to be establishment of the fact of damages and then quantification of damages.
Yes.
So even if we were to go by what they've said and rule against you, this is only establishing the factual basis for the claim. The next and the most important part is quantification, whether it should be 1 rupee or 10 crore rupees. So where is that quantification?
Yes.
It's not done separately under the head.
Now,
You have not shown us quantification on any aspect except interest.
Done separately.
yeah. There is, as my learned friend rightly points out, if your Lordship just goes to 129, there is no separate quantification under these heads. If your Lordship sees 129,
Yes.
the award,
Read it to page 89 first.
yes. In fact, if I may first show your Lordship, page 89 first.
Yes.
Now, how the learned arbitrators have proceeded is, they have first stated claim number 1 and 2, which are general, which merely says compensation for loss, extra expenses occasioned on the effect of stoppage, slowdown in the execution of works. Thereafter, my lords, they've taken all these heads, which, my lords, some of which I have dealt with separately. After that, my lords, when it comes to the quantification, if your Lordship goes straight away to page 129,
Done heads of expenses, but not heads of heads you have been on.
yeah. So, in the quantification, they've gone broadly, my lords, under broad heads of expenses, but there is no amount which is apportioned separately for each of those heads, or no amount of delay which is separately apportioned for all these different heads.
But he did the total amount at 780 rupees.
Yes. So it's general. So for example, my lords, the arbitrators don't say that for delay in supply of explosives, this is the extent of delay and this is the quantification I make. That quantification is unfortunately not done. What is done is a summation of the entire causes of delay without stating as to what is the amount of delay attributable to one particular head. Without stating that, a summation of that is done, and then thereafter, my lords, this quantification of claims is made on the basis of some machinery deployed or rental expenses and so on.
In their statement of claim, had they indicated these heads of claim? How had they proceeded?
I'll check
in
that.
their statement of claim?
Offhand, I don't want to give a response, Manoj. I'll just check that and I'll respond.
Because if they had not proceeded on the basis of, forget interest, delay in explosives, delay in, and then quantified,
Yes.
then taking up these heads,
Yes.
dehodes how it was presented, won't get the tribunal to assign any basis for quantification.
Your Lordship is right, Manoj. Your Lordship is absolutely right. In fact, that's something that even I was grappling with. That assuming your Lordships agree with me, let's say on 5 of them, and your Lordships don't agree with me on the other 5. Even then, thereafter, to be able to extricate that part and extricate this part, it's impossible. So that's a further, my lords, in my respectful submission, that's a further, my lords, error in the award, because having gone under these heads of claim, and that being the substratum of the award, the arbitrator should have returned a finding that this much delay is attributable to this aspect, this much delay is attributable to this aspect. Otherwise, it's very, very difficult to enforce this particular award if on 4 aspects your lordship holds in my favor and on the other 4 your lordship does not agree with me. Then it's very difficult to apportion and to be able to even, so to say, modify the award or implement or execute the award. That's my respectful submission.
The SOC has these heads as causes for hindrances, but does not appear to have a headwise quantification from what he's saying.
Yeah.
And it is from these heads that he's quantified.
Yeah. The SOC, my lords, also broadly articulates these heads. If your lordship sees the statement of claim, the arbitral record would be before your lordship. We will also make copies separately, my lords. Your lordship may just note paragraph 16, 1.6.3. They articulate these as the major hindrances which actually delayed the work. So some of these aspects, like condition of roads, etc., including, my lords, delay in supply of explosives, etc., are articulated. But even they don't say in their SOC as to what is the exact delay attributable to a particular hindrance, or what is the quantum of damages which they calculate towards a particular hindrance. That they don't say.
These heads are reflected in page 42.
Yes.
And what is the, ultimately, what is the amount claimed?
Yes, the amount claimed.
Claimed 40 crores.
Your lordship gets that entire thing in the form of a chart at page 780 of the appeal paper book.
780.
Yes. There is a chart, for example, under claim number 1.
Yeah, we have 780 open.
Yes.
Claim number 1. What is item number 1? Oh, that's claim number 1.
That's claim number 1.
So what is claim number 1?
Compensation for delay.
In the pre-suspension.
During the pre-suspension period of the contract.
And number 2?
Number 2 is post.
No, also pre.
Also pre, from a particular date, from which, my lords, they were supposed to complete to a particular date. So claim number 1 and 2 encompass the period prior to suspension.
So the award is 14 crores.
So award is, for example, claim number 1, the amount claimed was 4054. The amount awarded is 1482.53.
Where is the justification?
There is none.
That?
Headwise, there's no.
Headwise, there is no justification.
There has to be.
There is a sum total one.
No, there has to be.
Lordship
and
is-
sum total also can't be ipsit dixit.
I'll just scrutinize the pleadings myself in the
Mr.
SOC.
Dholakia,
Yes,
without shedding any blood,
yes.
take it away. We will not comment on anything, but we will say that it's not justified, and therefore without prejudicing either party, we'll let you claim it.
My lord, we have, my lord, given the justification.
No, where is the justification in the award?
No, my lord, what had happened in this case was we had given, my lord, an entire chart. My lord, delay by head by head. I'll tell you, lordships, what had happened. So, my lord, we said so many days of delay on account of explosives, so many days of delay on account of cement and so on and so forth. And the total number of days came to 520. Now, what the tribunal has done is to say that at a particular point in time when 520 days had expired, a progress of X percentage should have been achieved. Whereas on account of the delay, only 21% progress was achieved. So there was a shortfall of 79% in the progress of the work. So because there is no, because some of these are overlapping with each other. Some places where explosives are not given, cement is also not given, and so on and so forth. So it's not possible to attribute every single day of delay of explosives to the explosives delay. And therefore what it says is that because there is a shortfall of 79% of the work which could be achieved on account of these 520 days of delay, that is why whatever you have suffered, if there is idling on account of rent, idling on account of labor, so and so, for those number of...
Across the board,
Yes.
they've given you a percentage of your claim.
Lordship, sir.
And what is that percentage?
No, as I said, 79%. 79% is what we should, from what
It
we...
does not appear to be so.
Lord, I'll come to that.
If
I'll
you come to page 780,
yes, my lord.
it appears to be roughly 30% of your claim.
Let me not examine that. This is what has actually happened. That they have.
And we'll also require
Yes.
the arbitral tribunal's independent application of mind to that
Yes.
issue,
Right.
and its reasons.
Right.
We can accept what you're saying.
Lordship, please.
That across the board is very difficult. When
Yes.
engineering drawings have not been supplied, cement has not been
Right.
supplied. So to find out, yes, 2.5 rupees for
specify
that,
it. Correct.
1 rupee 50 paisa for that is impossible.
Right.
So you go on a general thing.
Right.
And what you say, we agree with it.
Right, Lordship.
That if 554 days
Yes.
of work, in 554 days, given the total completion was to be within, let's say, 780 days, you should have done so much.
Right.
And if you haven't done so much,
Yes.
what you're entitled to is the loss between the compensation would be what you ought to have achieved
Lordship.
and what you actually achieved.
I'm so deeply aware. That's what they've done. I want to show.
The reason should be there.
Yes.
We will not infer anything.
Yes.
We want cold reasons.
Yes, I see that, Milord. But Milord, apart from this particular point, Milord, I didn't want to interrupt my learned senior colleague, but there are a whole host of points, Milord, which have been raised, which were not raised before the tribunal. They were not, Milord, so therefore...
Mr. Amandi now has streamlined the argument.
Yes.
Has focused it on very clear 7 areas.
Yes.
And he is sustaining it or trying to sustain the challenge
Lordship.
by referring to findings, by contention,
Yes.
finding, agreement.
Yes.
And in the contentions,
Yes.
what he is citing from the agreement is referred to.
With respect, Milord,
If in some areas it is not,
yes,
we'll look at that.
Yes, that's what I want to show to you. So, Milord, in fact, as my learned friend, Milord, in some cases has shown your Lordship's 3 clauses. Whereas only 1 clause was cited, the other 2 clauses were not cited, which are the so-called prohibitory clauses. The question of interest, for example, Milord. Interest, Milord, was not pressed. There was no prohibitory clause, Milord, which was pressed before the tribunal at all. That neither, Milord, in the SOD it's there, nor, Milord, is it recorded as a contention in the course of the arbitral tribunal's award. Nor do they say in 34 that they argued it, but the 34 court or the tribunal did not record it. They, Milord, the tribunal, Milord, discusses the issue of interest and does go on to say, in fairness, I must say, my learned senior friend, Milord, had indicated that it discusses because I made a claim for interest. It goes on to say why it is I am entitled to interest, relies on certain, and Milord, in the course of that, there is just one stray line where, Milord, the tribunal says that we could not find any prohibitory clause. Not that they pressed any prohibitory clause, but they said that we did not find any prohibitory clause. Now, Milord, after the award has come, and your Lordships have seen 70% of the claim, Milord, is entirely about interest. Now that the award has come, Milord, they become wiser after the event and, Milord, they're raising it. And my respectful submission is, Milord, your Lordship's own judgment, recently given in NIPCO's case itself, Milord, less than a month ago, on 26th April, says, if you did not take the point before the learned arbitrator, then you cannot take it in 34-37 because ultimately your Lordships are testing the award which was passed by the arbitrators based on the facts and contentions raised before them. It cannot become, Milord, that your Lordships become the first judicial authority.
Interest is a different matter altogether.
With respect, Milord, I'm going to cite law on that point also. In Susaka's judgment, Milord, the Honorable Supreme Court says if you did not raise it before the tribunal, you cannot raise it later. Because you waived it. Under Section 4, there is a possible...
Capable of waiver.
Capable of waiver. You waived it. Now you can't turn around and say that because the tribunal did not have occasion to deal with that. Now your Lordships are testing the award. It cannot become, Milord, a situation where a party takes its chance, doesn't press that clause, and then says that, all right, now that the award is against me, let me, Milord, try and get it from your Lordships. That cannot be permitted. So my respectful submission is, I'll make good that argument. That, there are several other clauses.
But this quantification...
Yes, I see that. Again, quantification, I'll come back to that. Again,
but
34 and all that, no such argument was advanced. Now, this is for the first time before, even on quantification. I appeared in the court below.
No. No argument has to be made on quantification because a claimant has to earn every rupee that is awarded.
Lordship, please.
No argument has to be made on quantification.
Yes.
They are denying the head of claim altogether.
Yes.
Now the tribunal finds against them. The tribunal finds in your favor.
Lordship, please.
But then that is one part.
Yes.
Which is the ascertainment. in a claim and damages.
Correct.
There is quantification.
Yes.
There, every rupee that you get has to be justified.
Yes.
Why you deserve that rupee.
Lordships are right. Absolutely. And in my respectful submission, I justified it. Of course, my Lord, your Lordship will take a final view. I'm grateful. Sorry.
In the written submissions, as my learned friend pointed out something with regard to interest, there's a specific averment. Ordinarily, in arbitrations, post submissions having been concluded, there's a practice to file written submissions. That's at page 139. These very clauses have been cited. Second, even the arbitrators, they may not have said X clause number X, but they record my contention that no interest is payable. Categorically, even in the award, while dealing with this particular aspect. So it's not correct to say that submission has not been made.
Anyway, you know what is this?
This is part of my written submissions before the learned arbitrator.
Before the arbitrator.
It's part of the arbitral record. At page 139, these very clauses have been cited.
Thank you.
$130?
139 of the written submissions. I had made that.
In the clause 54 and 55.
Yes. And 54 and 55 is what I read to your Lordship. 55 was part of Appendix C, the first page.
Yes. So you get a kind of a preview of what the defense is going to be.
Yeah.
So you can cover a bit of that.
Lordship, please. So I was on this aspect of extraction of boulders,
Yes.
Your Lordships had seen our contentions at page 72.
You should move on.
Lordship, please.
Quantification, you have a point overall.
Yes.
But no merit in substance in extraction of boulders.
Just the submission that I was making.
Submission you have made is that you are only required to assist. Your requiring to assist has been interpreted by the arbitrators. There was a meeting between the chief ministers, out of which came 120,000 cubic centimeter, whereas the requirement was more than 100%, more than 900% of that. So therefore, and there were two subsequent lots of 10,000 which were released, which were grossly inadequate. They've interpreted it. We are not going to reinterpret that. But again, your point on quantification will remain.
Lordship, please.
But that's an overall point. But the head of claim is sufficiently justified in the arbitral award.
I take the point,
So both tunnel collapse and these go up to now. The others survive.
My only submission, that I respectfully would make, I can see my learned junior also egging me on to make it, is this, that if the contractual provision, the liability was only to assist, and I have rendered that assistance.
Assistance would be, you are required to assist. One has to look at it in a broad manner.
Very well.
They are a private party. You are a public party, quite influential in this area. It's a public project for the government of Mizoram, and therefore the kind of assistance that you would give is the kind of result that they would yield from your assistance is that they will be able to work. But the assistance that you rendered may have been wholehearted, but it failed to yield the desired result. And the arbitrators had the discretion to interpret that failure to deliver to be to your account. There we cannot enter.
Very well. So I'll leave it at that. I take your Lordship's point. Now thereafter, there are two further heads that remain. One is
construction drawings and
access roads.
And access roads.
Access roads. Access roads, your Lordship will get that the submission that we made.
Just a second.
Yes.
So we are now on access roads.
Lordship, please. The submission, my lords, is from page 67 to 69,
Findings,
90 to 93.
clause,
The relevant clauses, my lords, would be clause 1.3, that's at page 33
33 of
of Appendix A. Thereafter, clause 3.2.4, that's at page 36 of Appendix A. And there is a more general clause at page 37 of Appendix A. If I may just place those clauses, my lords, first. Your Lordship sees page 33 first.
I think if arbitrators were also to take up references on this structured way, it wouldn't take months. But there is the other interest which is there in arbitration,
Yes.
particularly if you indulge retired judges. Yes.
Though, my lords, as a member of the bar, I must concede that we also play a role, my lords, there.
Of course.
Certainly.
So
Most
therefore,
arbitrations begin with those were the days.
yes.
Yes.
Your Lordship puts it most aptly. Your Lordship puts it most aptly. Once upon a time.
Once upon a time, long ago. And then by that time that discussion is over, it's time for tea. And then you have to recapitulate for half an hour what happened the last time.
Lordship, please.
And then you start seeing it's time over.
Food for thought. Well, if your Lordship has one, it's page 33.
Yes, sir.
Your Lordship sees the highlighted part. The heading is General Description of the Turial Project. The principal access road to the project site is a state highway up to the village of Bilkhatwir, which is on the main road connecting Silchar, Assam meter gauge railhead and airport with connections to Calcutta, with Aswal. From Bilkhatwir, the access road crosses the villages of Saifai and Saifung. The latter is about 13 kilometers from the work site. The actual distance from Bilkhatwir to the work site is about 45 kilometers. The track crosses several rivers on old bridges. The access road is under improvement by NIPCO and Border Road Organization. Another access road is under construction from Bhaga Bazar up to Saifai village and is likely to be completed within April 2001. All local access roads are to be constructed and maintained by the contractor to facilitate the execution of the project. This clause, my lords, I am only citing for the purposes of demonstrating that they fully knew what the conditions of the road were at the time when they made their bid. Now, my lords, kindly see page 35 under 3.2.2. In the project area, the approach road up to Saddle Dam site, including other local access roads and various working fronts, are at present being constructed by NIPCO. The existing access roads in the project area have to be accepted by the contractor on an as-is-where-is basis for their work. The access road to dam and spillway inlet, including the other local construction roads and other road facilities, are to be constructed by the contractor to facilitate execution of the project. The maintenance and repair work of all the above roads will be the contractor's responsibility. I'm only emphasizing on as-is-where-is basis. Thereafter, please see page 36, Mulaz. Now here, 3.2.4 may come within the category of express bar. NIPCO will be responsible for the maintenance of principal access road during up to temporary dam camp during the project construction period, bidders should be aware that the entire roads in the area are prone to damage and blockade during the monsoon seasons. Along certain stretches of the access road, the slopes above the road may become unstable when saturated by monsoon rain, and the road may be blocked by the resulting landslides and rockfalls. Such blockades will, in general, be cleared by NIPCO or any other authorized agencies as soon as reasonably possible. The bidders are strongly advised to make their thorough inspection of the entire access roads, to appraise themselves of the status of the upgrading of the roads and bridges, and to make their own assessments of when the various stretches of the roads will be completed. Those assessments must be taken into consideration when preparing the bids. No extension of time for the completion of works will be granted as a consequence of such occurrences, except if the road is blocked continuously in any single location for more than 10 consecutive days, and only if the contractor can prove that this blockade has directly affected the work schedule. Claims by the contractor for additional payment as a consequence of blockade or damage to the access road will not be entertained, irrespective of the duration of the said blockade. So 3.2.4 minutes comes within that fulcrum of express bar, the last 3 lines, which I wanted to point out.
Read it once again, please. Claims for?
Claims by the contractor for additional payment as a consequence of blockade or damage to the said access road will not be entertained, irrespective of the duration of
And
the
what is the said access road?
The said access road is, Mullahs, the main highway. Your Lordship has that at 3.2.4, which says maintenance during construction of the project. So his claim was that the access roads actually delayed the movement of vehicles, which led to a delay or not being able to meet with the time schedule. Now it's one thing for the arbitrators to say that on this ground you can't claim damages because the access roads are not adequate, there is a sufficient explanation. Another thing to say that despite the fact that you knew at the time of making your bid that this was the condition of the access roads, now you say access roads were not properly maintained, there was damage, there were blockades, and therefore that delayed my completion of the project, so pay me damages for that. So in my respectful submission, apart from 3.2.4 constituting an express bar, also, my lords, a reasonable construction of all the clauses that I read would clearly show that no damages, that no reasonable person could have interpreted those provisions to award damages to them. It was very clear from the beginning as to what you were getting into. The information to bidders made it very clear as to what the conditions of the access road was. You should have tailored your bid accordingly. That's my submission. Just one more clause, my lords. If your lordship just goes over the page at page 37, just about 3 lines from the top, the maintenance of these roads will be the responsibility of the contractor without any extra cost to NIPCO during the entire construction period pertaining to the contract. All other approach roads as may be required for performance to the contract shall be constructed and maintained by the contractor at his own cost without any liability of reimbursement by NIPCO. Besides, the contractor may use the alternate road from Sher Khan to Saifun.
NH 54.
That's correct. So even here, my lords, it is mentioned that no extra cost to the contractor.
Point out that NIPCO is responsible for the principal access
Yeah.
road.
Now I must point out something against me, my lords, that for maintenance of the principal access road, I am responsible. There's no doubt about it. He is responsible for maintenance of the road within the project site. But a cumulative reading of these clauses, the only conclusion that can be, my lords, fetched from a cumulative reading is that even if there was some delay in movement of vehicles, etc., on account of the access roads not being in pristine condition, you can't get any damages for that. You may be entitled to extension of time. You may be entitled to also say, I am not liable for the slow progress of the work. But you can't get any damages for it. That's my respectful submission to your lordship. The tribunal, my lords, there deals with this particular, if your lordship just sees, the submissions.
No, Mr. Amity just envisages the situation. We can't be divorced from what the situation would be. Let us say I have heavy machinery and I have brought in men and mason to run that machinery. And that should have taken 2 days to reach. It takes 20 days to reach. My men and machinery, my men and mason are lying idle. The rest of the machinery is lying idle. Your access road impedes the progress and delays it from 2 to 20. Nothing that you've read prohibits that kind of damages to be taken into consideration.
May I respond to that? Yes. Suppose today, when...
Because we've got to give commercial meaning to
yes,
these.
Certainly.
They are not, edicts written on stone.
Yes,
they
certainly.
have to be relatable to the kind of project.
And a practical view has to be taken. Because I take the point. So the way I would put it is this. If today, at the time when originally... Sorry.
The gentleman behind you, has he come from outside? Yes, we will be probably taking most of the day. So if you want to, you pick your date and you can come back some other time.
I'm sorry, my lord, in the second half, my lord, I'm in some difficulty.
He will not finish by then.
No, my lord, my learned friend told me that he would, so that's why I was just
By
wondering.
lunch, I think I should finish.
Don't think so. So you inform your other side?
Yes.
And we will give you your desired date. Just find out from them. Yes.
Yes.
Sorry.
So purely from a commercial viewpoint, Mulaz, may I give the answer from both a commercial and a practical viewpoint. Now, when this kind of a tender is floated, I mean, it's a fairly complicated tender, and you have fairly experienced parties who pretty much know that to construct a dam, what are the pitfalls. That apart, in the original bid documents, these clauses mirror what the exact condition is of the access road. So when you put your bid on various items of the BOQ, you specifically factor the delays and the transportation cost that you will incur, including, my lords, the cost of manpower, including the cost of machinery. All that, my lords, is a sum total of the various items that you bid for the BOQ. Now, suppose I had concealed this fact, in the sense that my original tender document did not state or did not allow a proper site inspection. Then your lordship is absolutely right that I bid for a particular tender for the items in the BOQ on a particular basis on a reasonable assumption that a road which traverses, let's say, 50 kilometers will take me approximately 1 or 2 days to reach, even on a mountainous terrain. That's not the fact situation here. The fact situation here is that the entire condition of the road and the pitfalls and the dangers which are associated and the delays in the transportation would clearly be factored in by any experienced contractor when he makes a bid and bids for respective items in the BOQ. So if he knew this from the very beginning, then, my lords, he can't later on turn around and say, pay me because it took me much longer than what I originally anticipated on account of the bad conditions of the road, which you knew very well at the initial stages. That's my respectful answer.
One more thing which has to be added over here.
Lordship, please.
You don't give a bidder the choice of indicating completion time. That is not a variable. That's a fixed.
Yes.
So when the conditions are not good enough for that target to be achieved, then you're diluting much of your argument by giving a fixed completion date. You could have said you make an assessment as you're interpreting them, the clauses to mean, and then you say that, tell us, how long will it take and how much will it cost? Basically that. But you are not giving them the option of how long will it take. You want it tomorrow. But the conditions are not such that it can be completed by tomorrow. They see all of what is there, they make provision for the worst as they ought to. But they're looking it to end by tomorrow. Whereas your tomorrow, in most of these government, is a very unreal tomorrow, which will naturally stretch to many months after tomorrow. So the moment you give that, make that not a variable and fixed, a lot of this that you are assigning to the contractor or attributing to the contractor gets diluted. In the plain commercial context.
Yeah. I would only, respectfully, that's a possible, but I quite take the point. And it happens, repeatedly in these kind of construction problems.
Why are they like this?
Yes.
You know, it's penny wise, pound foolish.
Yes. Perhaps, the date of completion should be more realistic. But I think, targets need to be met for various other reasons. That is why certain dates of completion are fixed. Because ordinarily, in a lot of these contracts, the funding comes from various other agencies. So it's, I think, on that basis and budgetary allocations which influence the completion date. But I would only, respectfully point out one thing, and I end on this particular aspect. I can also take your Lordship through the reasoning to only show that the reasoning does not adequately factor the meaning of these clauses. But all that I have to say is this, that if it is shown as a matter of fact that on account of the excess roads, it's not possible for them to have achieved a particular target within a particular date, they are fully entitled to say, I can't be held liable for the delay. But when they formulate their BOQ and give their bid for individual items, having factored that delay, to get anything more on account of that delay is something which the contract cannot be construed to contemplate. That's my respect, sir. I don't want to go beyond that.
In the BOQ,
yes,
they can't exceed the time limit that you give them.
Yes. As per the BOQ.
As per the BOQ.
Yes.
So that additional time, 300 people they'll employ. But the 300 people will be employed till X date, which is your cutoff date. They can't envisage or they can't even quote to you that this cutoff date is going to be stretched by 3 months and therefore that should also be taken into account. Whenever there is a delay in a commercial project like this, it naturally follows that there's a cost factor.
Your Lordship is right.
You cannot just say, I'll give you extension, but I won't give you money.
Yeah, Your Lordship is right.
That's a commercially...
Your Lordship is right, beyond what my respectful submission to Your Lordship, which I was bound to make, I have nothing more to say in this regard. But I am only trying to emphasize the point that everything was laid bare by us to them. And they got into it. Now they can't be really turning around and saying that because the excess roads were not in pristine condition, pay us more for the deal. That's my respectful submission. So the next point is with regard to...
You're left with the findings.
Yes, the findings, my lords, in this regard, Your Lordship will get pages 90 to 93.
Yeah. And fair enough also.
Yeah. Well, the findings are in this way, my lords. If Your Lordship comes from page 90, A, yes. The arbitral tribunal reproduces the sketches which show the different roads leading to the project area to have a better understanding of the contentions raised by both parties. The arbitral tribunal notes that the principal access road from Silchar to project area, as shown on the contract, comprises road section Silchar to Vaga Bazar, to such and such, to Sci-Fi, to Saifum, to project site, and is of the length 35 plus 10 plus 26 plus 18 plus 15.60 plus 11.60 is equal to 116.30 kilometers. In the contract, the distance is stated as Sci-Fi Saifum 0.17.6 kilometers and Saifum 0. Project site is equal to 13 kilometers. The above length, that is 35 plus 10 plus 26 plus 18 plus 17.60 plus 13 is equal to 119.60 kilometers. The contract states that this road was to be provided by the respondent. The AT takes cognizance of different clauses of the detailed work order dated 13/2/2002, including clause 15 in this regard. May I skip that? It's not very relevant.
Yes, you come to state those three conditions.
Yes.
By October 2001,
Yes.
and 25 to 30 speed,
Yes.
and gradient of 10.
Yes. All these, my lords, were mirrored in their
And this should not be 10%, gradient should be 10 degrees.
Yes. Yes, yes, my lord. Your lordship. And then thereafter, the defenses are noted at page 92. The second point, my lords. The AT has noted the defense by the respondent in respect of the principal access road and project roads, wherein the respondent has alleged that the claimant knew well the condition of access road prior to the submission of bids and had to maintain them, to use them on an as-is various basis. The AT finds this contention of the respondent as contradictory to the express provisions of the contract, especially the statement made by the respondent in the detailed work order regarding the access roads. The AT notes that the condition of the road which was required to move heavy machinery to the project site via access road, that is from Bilkhatwe to Saifum, was being constructed by the respondent along with the BRO, and from Baga Bazar to Sci-Fi with Assam PWD was to be made available by April 2001. This principal access road was to be maintained during the entire project construction period by the respondent, a responsibility taken by the respondent upon itself and provided in the contract. In the case of the access road, Saifum to project, an approach road to diversion tunnel intake, an outlet was being constructed by the respondent, and all the existing roads in the project area would be handed over on an as-is various basis to the contractor for maintenance. Although the contract commenced with effect from 28/9/2001, the respondent within the first 4 months available for mobilization did not make available the principal access road constructed to the requirements stipulated in the construction program forming part of the contract. Till as late as June 2005, in this connection, the AT takes notice of the claimant's letter dated 15/6/2005 that even the applied extension period up to 34/2005, the said road was not made available. The AT takes note of the relevant portions of the record note of discussions held on 23/3/2003, issued by the respondent on 27/3/2003. The AT has noted that in terms of the contract provisions, the principal access road, that is Bilkhatweer, Saifum, Dam Camp Road, section was responsibility of the respondent, but the same has not been completed even close to the ending of the original period of completion. The AT has deliberated on the respondent's argument that the notes in the construction program and the construction program itself do not form part of the contract. The AT has perused the contract documents and provisions therein. The AT has noted that the record notes of negotiations between the parties dated 27/9/2001, wherein the claimant was asked to study the proposals of the respondent and submit their proposals by 8/10/2001. The AT also notes that the respondent in its LOI dated 28/9/2001 had asked the claimant to submit its construction schedule along with other details as were discussed in the negotiation meeting held in New Delhi on 27/9/2001. The contract agreement also states that the contract consists of the following covenant parts, which are fully a part of the contract as is set out, verbatim if not attached, as if here to attach. The AT notes that in accordance with the above instructions or provisions, the claimant submitted its construction program on 12/10/2001. In reply to the letter of intent issued by the respondent, the AT construes that by this reasoning, the construction program becomes part of the contract and the notes or conditions stated in the same are binding on both the parties. The AT states that the respondent was obliged to provide access roads as required under the construction program. Non-fulfillment of this fundamental and essential requirement, which are in the nature of contract stipulations, will result in fundamental breach of the contract. The AT notes, it goes on in this vein, is the sum and substance.
Sufficient justification.
I have nothing to add, to the submissions already made. The 10th is,
Construction drawings.
construction drawings.
10th?
I mean, the next, that's in my note.
Actually 7th on merits.
7th, yes. So the next is the construction drawings. In the light of what has fallen from your lordships earlier, and the rarefied ambit of section 34.
37.
Though, I've urged that point and I'm bound to urge it. I don't really see my being able to make out a case for interference.
Just give us the...
I'll just give your lordship the...
contentions, findings and the clause.
The contention is at page 60, 69, 70.
Findings?
And the findings are at page 95.
Clause?
There is no specific clause with regard to this. The sum and substance of what is stated is that you ought to have given construction drawings in advance for them to be able to meet the work schedule, and there was delay on your part. So this is purely factual. The only contention raised is, in the appeal, is that we gave a letter where we said you were responsible for the following slippages in the time schedule, and that's not been adequately dealt with in the award. That's the only point that is made. So I leave it at that. Now, with this, I am done insofar as claim 1 is concerned. Interest, claim 1 and claim 2. Your lordship will only note that interest is a factor which runs across lots 1 to 3 and the last two contracts with regard to the construction of the road. So that's common to all. Now, insofar as these heads are concerned, which I had highlighted, they are only relevant insofar as claim 1 is concerned.
Claim 1 and 2.
Claim 1 and 2.
In lot 1.
Yes.
In lot 1. Because claims 3 to 5 relate to the suspension period.
Interest covers all 5.
Yes.
2 is...
I had made an overview note highlighting this. May I handle it?
I'll just
yes.
take it down. 2 is points 2 to 7.
Lordship pleases.
For lots 1 and 2.
Correct. Lots 1 and 2.
Lot 1.
Only lot 1.
Only lot 1.
Lordship pleases.
The award is a common award.
No, Lords. There are separate awards for different lots, but overlaps are common. I mean, the sum and substance of all the awards are common.
Is on the same date?
3 on the same date, Lords. And
roadways is 14/10/2006.
And the roadways date is different. That's 14/10.
Just give it.
I'll just give it to your lordship on a...
Roadways is 14/10. That's 2016.
2016.
Yes.
And the other ones are?
21/8/2016.
21/8/2016.
21/8/2016.
Yeah.
Lots 1, 2, 3. Yes.
Yes. Now, insofar as, my lords, the other claims are concerned, that is claim 3 up to claim 5.
And which was 1, 2, 3 in all the others.
No.
Yeah.
Claim 2 to 5.
3 to 5.
3 to 5.
No, you have said these points are only right for lot 1.
Claim 1 and 2 in lot 1.
Claim 1 and 2 in lot 1.
Claim 1 and 2.
In lot 1.
Meaning interest and delay in supply.
Yes. Yes.
No, interest in all.
My lords, just one. Interest, my lords, common. Delay in supply
Delay of explosives and delay and short supply of cement.
Yes, all these other points, explosives, short supply and cement, tunnel collapse, rock strata, etc., they're all peculiar to claim number 1 and 2 in lot 1.
Lot 1, yes. Point numbers 2 to 7 in lot 1.
Lordship, please.
Then,
And so far as, my lords, claims 3 to 5 are concerned,
meaning those lots
No, claims 3 to 5 in lot 1.
in the references.
in the references,
Third to fifth references are concerned.
no, my lords. Claim number 3 to 5 in lot 1,
Yes.
the points covered are relevant to lot 1 and the other lots, that is lot 2 and lot 3, as well as the roadworks. So claim 3 to 5, because they pertain to the period when the contract was suspended, the submissions that I made with regard to the different heads are not relevant with them. So those are common to all the lots, that is claim 3 to 5.
They correspond with 1 to 3 in all the other lots.
In the other lots, claims 3 to 5 are claims 1 to 3.
Don't follow.
Yes. 1 minute. My lords, claims 3 to 5,
There were 5 references.
yes,
They pertain to lots 1, 2, 3
Yes.
and 2 road.
and 2 with regard to the roadworks.
Very well.
Lordship, please.
All the 5 references were taken up together.
Yes,
Now, therefore, we'll expect claims which are common through all, or claim in respect of lot 1, lot 2, lot 3 and the 2 road ones.
Lordship, please.
Now, the 2 road ones appear to be common.
Yes,
Now, lot 1, lot 2 and lot 3 are for what? Different periods of time?
yes.
Different contracts.
They're different contracts for different periods of time. So what happens is, my lords, that so far as claim number 1 and 2 are concerned, all the heads that I had pointed out in lot 1, they are only relevant to claims 1 and 2. Claims 3 to 5 in lot 1 are for the period when the contract was under suspension. Claims 3 to 5 for lot 2 are also for a period when the contracts were under suspension. So in lot 2 they become claims 1, 2 and 3.
May I assist you?
And,
Sorry.
no, go ahead.
Lord, I can assist if your lordship would permit me. Now, my lord, there are 3 lots. I'm not keeping the road contract separately. The 3 lots are for 3 different, my lord, works. One is, my lord, civil works for diversion tunnel, my learned friend showed, my lord. Second is, my lord, civil works of dam and spillway, and the third is civil works of powerhouse. So, my lord, 3 different lots. Now, under each lot, there are a number of claims. Now, for the lot 1, there were, my lord, 7 claims. The 7th was rejected, not challenged before your lordship, so there are a total of 6 claims under that. Now, claims 1 and 2 under lot 1 are for the period prior to 9th June 2004, which is the date on which the work was suspended. So, 2 periods were separated, that's why it's not claim 1 and claim 2, but it's for the period prior to 9th June 2004. Now, my lord, claims 3, 4 and 5 are for the period during which the work was suspended from 9th June to 31st March 2005, that is claim number 3, 1st April 2005 to 30th June 2005, and then 1st July 2005 to 30th September 2005. So, my lord, that is how it has been divided. Now, when we come to lot number 2, it does not concern claims prior to, my lord, the suspension. It only concerns the claims post the suspension, and that is how they overlap with the 3 other claims of the lot 1. I don't know, my lord, if I am making myself clear. That is
Somewhat.
But I had prepared
I can pass on a chart, my lord.
yes, I had prepared a note. Perhaps that will assist your lordship. Pass a copy to him. Just give him a copy.
Lot 2, there is suspension of work.
You take it from my magazine. It's there, yes. You read along with me if there's any explanation you want
You
to
have
give.
argued this. You have argued this. So you've argued this. This is what you have argued. This is what is you have. Thank you.
That were argued from here.
So interest you've argued. The suspension. This is what bias and splitting
Yes.
Yes. So, Manoj, I've tried to clarify these aspects in the note, in the overview note. Manoj. The contract in the present case was entered into on 22/2/2002. The dam is complete and was commissioned in the year 2017. Project was suspended from 9/6/2004 to 13/1/2011. So the other lots, that is from lot 2 onwards, cover, my lords, the suspension period.
because the completion of the start date was after the suspension period.
Yes, because the start date, my lords, was after the suspension period.
Completion dates.
The completion date, my lords. Thereafter, impugned awards in the present case concern the period till 30/9/2005. This is referred to as reference 1. Reference 2 covers the period 1/10/2005 till 14/1/2011. This, my lords, reference, that is the second reference, is before another arbitral tribunal.
Same laws.
With regard to, my lords, the same law.
This is Justice Patnaik, Justice Roy, and
Lordship, please.
third.
Yes, it's at the stage of final hearing.
Suspension occurred.
Yeah. In fact, my lords, some issues are common. There's an overlap. Only lot 1 had a completion date prior to 9/6/2004. That is the date of suspension. Therefore, only lot 1 has claims for the pre-suspension period. These are claims 1 and 2, and the various heads other than interest under which submissions have been made on 22/5/2023 concern claims 1 and 2. While the delay claims regarding the period prior to suspension only concerns lot 1, which is the subject matter of arbitration number 1/2023, the following claims or issues permeate all the lots or appeals. Interest, that is pre-award interest given in all the lots. Claims towards compensation for losses, extra expenses incurred during the suspension period. Claims 3, 4 and 5 in lot 1. Claims 1, 2 and 3 in lot 2. Claims 1, 2 and 3 in lot 3. Claims 1, 2 and 3 in 17.60 kilometer roadworks. Claim 1, 2 and 3 in 13 kilometer roadworks. Claim for reimbursement of extra cost of transportation through the longer route due to non-availability of shorter route via Bagh Bazar, Sci-Fi. Claim 6 in lot 1, claim number 4 in lot 2, claim number 4 in lot 3. Note, claim number 7 in lot 1, claim number 5 in lot 2, and claim 5 in lot 3 were towards cost of excess cement used in shotcrete, which was rejected by the tribunal. This covers all the claims.
Bias and splitting the reference from across.
We'll go there. I hope, my lords, this to some extent clarifies.
What is shotcrete?
Shotcrete is, my lords, It's like a spray concrete, Maharaj. It's a different kind of cement that you have. I think it requires slightly different kind of like cement.
Mixture, aggregate and pot.
Correct. So, my lords, I had finished my submissions with regard to the heads under claims 1 and 2 in lot 1. I had already made my submission, my lords, earlier with regard to the splitting of the references being against, my lords, the spirit of the order passed by the Honorable High Court, my lords. I come now, my lords, to the other claims, that is claim numbers 3 to 5, which is, my lords, essentially in respect of the suspension period. Now, my lords, I must candidly state, my lords, that the submission that we had made was that the suspension was occasioned by force majeure conditions. On account of unrest in the area, there were bunds called, etc. The tribunal, my lords, has threadbare discussed those defences, my lords, and has ultimately, my lords, come to the conclusion that those defences, my lords, do not really hold water, and your case of force majeure is not made. Now, I have challenged that finding, but I must candidly state, my lords, that probably before an arbitrator it was possible to argue on the evidence that force majeure was made out. It's not possible within the limited, my lords, remit of section 30 for me to urge that the finding that there was no force majeure is wrong, my lords. I would say that it is wrong because that's what I have pleaded in my appeal, my lords. And it also impacts me in the other arbitration. But all that I wish to say is that for the purposes of section 37, for the purposes of this appeal, presently, my lords, apart from stating that the finding is wrong, my lords, I can't really bring it within the rarefied remit of 34 or 37. Yes. However, my lords, there's one point that I wish to make, that after having held that there was no force majeure, therefore they were entitled to be paid for the suspension period, the tribunal has simply picked up the computation as per certain charts which were handed over by the respondent, giving certain heads of expenses towards machinery, towards X, towards Y. So idle labor, machinery, etc., etc. This has been accepted across the board without any primary evidence in that regard. So, for example, suppose you say that I have purchased a machine, the invoice for that machine is not produced. Suppose I have so much of labor on site, that primary evidence was not before the arbitrators. That's my respectful submission. I state this on instruction and the limited arbitral record that I have gone through. So all that is in the calculation or in the aggregating of the amount or in the quantification, all that the learned arbitrators have gone by is the chart submitted by them. Now, in our pleadings, we specifically deny even the factum that the actual cost that was incurred is as per the chart submitted by them. So therefore, without primary evidence in this regard, the arbitrators have gone wrong insofar as a matter of quantification is concerned. That's my limited submission. For that, my lords, I'll only show your lordship one clause, that is clause 22B, which stipulates that if during a particular period you are supposed to be paid, you will be paid on the basis of cost. So cost, my lords, one way of looking at it is actual cost. The other way of looking at it is quantum merit. Either way, my lords, the claim has not been proved. Unfortunately, that was not part of the appendix, my lords. May I just hand over that particular clause?
Thank you. Thanks. Application will be reasonable.
Your Lordship sees clause 20, just on the first page. It's printed page 61 at the top, I think. Suspension of works. The contractor shall, on instructions of the engineer, suspend the progress of work or any part thereof for such time and such manner as the engineer may consider necessary, and shall during such suspension properly protect and secure the works or such part thereof so far as is necessary in the opinion of the engineer. Then the rest your Lordship may ignore. Your Lordship may come to clause 2. Engineer's determination following suspension, where pursuant to clause 21, this subclause applies. The engineer in charge, after due consultation with the contractor, shall determine A, any extension of time to which the contractor is entitled under clause 24, and B, the amount which shall be entitled to the contractor in respect of the cost incurred by him by reason of such suspension. Such amount shall be payable to the contractor, provided suspension is continued beyond 28 days, beyond continuous 28 days, resulting in total stoppage of the work in all fronts. So, what he is entitled to during the period of suspension is the cost. Now, in this context, if your Lordship would be pleased to have the findings of the learned arbitrator on quantification. First, your Lordship will just see my contention at pages 79 and 80. Correct. At 79 minutes of the award.
Where are the findings?
The findings, my lords, your Lordship will find from pages 139 to 144.
137 it starts.
Yeah. In fact, my lords, the entirety of the findings start from 137 to 144, not 139. My lords. If your Lordship just sees my contentions at page 79, Roman small 6 and 7, the respondent denied the averment, submissions and allegations made by the claimant for claim numbers 3, 4 and 5. Page 79, my lord, of the award at the bottom. The respondent denied the averment, submissions and allegations made by the claimant for claim numbers 3, 4 and 5. The respondent also denied the quantification amounts for the claim numbers 3, 4 and 5 and stated that the different heads of quantification were based on no material and were without any reasonable and equitable basis. The respondent stated that despite instructions given to the contrary from time to time, the claimant had withdrawn most of his resources at site during the period under question, and an elaborate inquiry is required to ascertain the validity of the claims before the arbitral tribunal towards any amount to the claimant. The claimant finally denied any entitlement for compensation to the claimant. Now, the discussion, Maras, on the question of quantification, your Lordship will get from page 137 onwards. I'll read all of it, my lords. And my submission is that there is no primary evidence to justify the quantification. If your Lordship sees page 137. The arbitral tribunal, your Lordship has it? The arbitral tribunal notes that the claimant has cited extensive arguments in support of its claim and the quantification of head office overheads and profit. The AT does not wish to reproduce the entire argument for sake of brevity. The claimant has cited references of CWC guidelines, which also recommended 20% towards overheads and profit. The claimant also argued on the bifurcation of the on-site and off-site overheads in its submissions and explained the importance of considering both the aspects while quantifying the claims. Finally, the claimant has cited Hudson's book on building an engineering contract in support of its contentions. Keeping in view the specific stipulations regarding the percentage of overheads and profits at 10% each in the contract, any higher percentage cannot be considered in the computations, and accordingly the arbitral tribunal has, as per the contract provisions, considered the following CWC guidelines. Central Water Commission guidelines for preparation of project estimates for River Valley projects, March 1997. Central Water Commission Guidebook for use rate, hire charges and transfer value of equipment and spare parts, December 1988 edition. Accordingly, the arbitral tribunal has considered the following factors. Basic labor wages plus 80% for skilled labor category, Annexure 2 breakup of direct or of indirect wages payable to workmen on River Valley projects. Basic labor wages, that is 55% for semi-skilled category, Annexure 2 breakup of indirect wages, benefits payable to workmen on River Valley projects, etc. Hourly depreciation on the basis of CWC guidebook on the use rates, hire charges and transfer value of equipment and spare parts. The planning was carried out in the negotiation meeting held on 27/9/2001. Planning submitted V-Day letter dated 12/10/2001. Agreement book as per data sheet 8, construction method. All that I can skip, Malats. If your Lordship goes over the page at page 139, clause 5. As regards machinery and manpower, the AT notes that the claimant has filed a letter dated 7/6/2004, which gives list of machinery and equipment manpower and PRWs. The AT further refers to the claimant's letter dated 1/11/2004, which is addressed to the respondent, which has been filed by the respondent along with the application dated 31/7/2009 in front of the tribunal for records. The AT notes that there is no denial from the respondent's side on the facts presented by the claimant. Thus, the AT considered the machinery, equipment and manpower to be jointly verified and considers the same for its computation. But this, in my respectful submission, is a completely erroneous finding. Because in my pleadings, as has been noted, Malas, by the arbitral tribunal earlier, I have denied the claims, and I have denied the factum of there being any material. As regards interest claimed, etc., that your Lordship may skip. Now, these are the different heads under which, my lords, amounts have been awarded only on the basis, solely on the basis of the list produced by them. Now, just to give your Lordship a flavor of how the calculation has been done, your Lordship may just go to page 151. 151, my lords, is annexure 1. Is annexure 1 to the award. Now your Lordship sees at the top, says particulars of equipment, year of purchase, date of induction, quantity, cost of machinery, total cost of machinery, then machinery transferred, then recommended life in years and recommended life in hours. These are the heads. Now the point is that suppose, for example, you have this machinery. In order to make out your case, my lords, on quantification, in my respectful submission, some primary evidence must be laid or some documentary evidence must be filed to show that this machinery was actually purchased and deployed on site. That has not been done. The learned arbitrators have gone, my lords, only by the lists which they have provided, saying, I have deployed the following machinery.
Did you deny it?
My lords, in my pleading, I have already shown your lordship that page, which is recorded by the learned arbitrators, where I say that this is denied. Claims, my lords. Your lordship has already seen page 79 and 80. Roman small 6 and Roman small 7. And I have said that the quantification is based on no material.
Only put a question that the logbooks have not been produced.
Yes.
Have not been filed in cross.
Yeah. And in the cross-examination, my lords, answer number 60, around between 66 and 68, 67, it has been put that you have not produced any primary material in terms of logbooks, etc., to be able to demonstrate the actual use of this machinery or manpower on site. So ordinarily what happens is, my lords, when a contract is suspended, there is also a responsibility on you to mitigate. So I am not, for a moment, I am not in a position to challenge the finding on force majeure, that there is no force majeure. But the quantification and each and every penny which is awarded has to be actually proved in terms of quantum, which hasn't been done with primary evidence. That's my respectful submission. So insofar as claims 3, 4 and 5, my lords, which are common across, my lords, the other lots, that is my respectful submission, my lords. There is a claim number 6, my lords, on transportation, where, my lords, I have also challenged that in my section, in my appeal, but, my lords, I'm not in a position to make any submissions in that regard. I mean, I can't give it up, my lords, because I'm not under instructions to give it up, but that's all that I have to say with regard to that claim. So I now, my lords, come back to the last two. One aspect, my lords, which occurs in my respectful submission, which may be, my lords, of some relevance, is this, my lords, that suppose your lordships were to find that under the heads under which the award has been made, 5 heads are justified and 5 heads are not justified. From the material placed in the award, it is not possible to extricate the period of delay attributable to those 5 heads on one side and the 5 other heads, because the arbitrators have not conducted that exercise in the award. And therefore, my lords, in those circumstances, the award would not be capable of execution at all, because then the entire issue of delay gets jumbled up. As well as, my lords, the issue of quantum.
The saving grace is that when you go to execution, you don't execute the judgment, you execute the decree.
That's correct. But at the same point of time, my lords,
what you can say is that we cannot give you that decree from the award for you to execute or for them to execute. Because if we were to extricate the impermissible from the permissible, we won't be able to quantify the quantum of impermissible from the quantum of permissible. And therefore, we can't reduce it to a decree for them to execute.
I'm deeply obliged, my lords. I couldn't have put it any better. I'm deeply obliged to you, Lord.
So all that is left is splitting. If you want to
Yeah. So the last two submissions, Malaz, I had originally made. One is, Malaz, with regard to the splitting of the references.
Splitting of reference, you said.
Yes.
Splitting of reference. Give us the order.
Yes. The order passed by the...
Order of reference.
Yes. That's page 502 to 510.
Of the appeal papers.
Of the appeal papers. Relevant part is at page 519.
Please read out the operative part.
Yes, Manoj. Page 519, if you're okay with it, please. It's at the appeal paper. Where is it? Give it to me. Oh, Manoj, I think I've got the wrong. I beg your pardon, I've got the wrong paper book. It's at page 519.
No. This isn't right.
Volume 5, I think so.
Yes, there is a.
We had handed over last time.
But where is my volume? I'm sorry, Manoj, I apologize.
Just extricate the order and give it to us.
Yes, Manoj. It's at page 519, I think, of volume 5.
Of volume 5.
It was originally there in a...
You're looking for the High Court order. Page 502 of the appeal.
That's what I also thought.
502 of the appeal.
There's no 519 in volume 5.
My learned friend is right. It's 502 of the appeal paper book.
You said right when you said 502 to 510.
Yes.
But then you said at 519. That is wrong.
Yes.
It should be at 509.
Yes.
Relevant part is 510, para 14.
Yes. Para 14 at 510 is actually the operative part. All the petitions reserved to and are accordingly allowed in terms of clause 70 of the contract read with clause 2 of the agreement of reference, hereby directed the panel of arbitrators already appointed would take up the present dispute and would decide the same in accordance with law. The petitioners may appear before the panel of arbitrators and file copies of the order before them, enabling them to know that they have been appointed as arbitrators and they are required to receive claims, replies and counterclaims and are required to decide the matter in accordance with law. All the arbitration petitions are disposed of accordingly. The last, Manoj's overarching point was bias, Manoj, where I had made my submissions earlier. I had also handed over that list of dates on bias along with
That you have to do it again.
Very well. Broadly, Manoj, if your lordship just goes to those list of dates along with Appendix B.
Appendix?
Along with Appendix B, there is a list of dates, Manoj. There's a volume which I had handed over last time.
List of dates.
Yes, Manoj.
Para 3 is the summary.
Page 1232.
Lordship pleases.
So now you're on bias. And you cited that Air India case.
That's correct.
Who was that? Justice Chagla? Whose judgment was that?
I think
Tendulkar.
Justice Chandrachud.
Senior
Justice
yes,
Chandrachud.
yes. YV.
Lordship, please.
Somebody.
Yes.
You don't have to cite the judgment, we'll just take the reference because I remember and
Lordship, please.
facts are completely different.
That's what was pointed out to me. So, if I may just quickly run through this list of dates, Manoj, that para 3 actually at page 6 articulates my case on bias. One is the question of hospitality and non-disclosure, as well as, my lords, the representation of the arbitrators by the learned counsel for the claimant, and the tenor of the application under section 27(3), which are also asked for penal action against the respondent, which was filed by the claimant's lawyer, by the respondent's lawyer.
Page,
If your lordship just sees page 6,
page 6.
that's just a summary, my lords. It is thus apparent from the sequence of events narrated above that the
Page 6 has dates of 2000, 2000 and those.
yes, that's just, my lords, to complete the sequence of dates.
Yes. And then
list of dates. Page 6 of the list of dates, page 1 to 9.
Yes, his lordship has
we are
got.
looking at the list of dates which
Yes, his lordship.
on the cover page says 1 to 32.
No, so that's the other one.
And the
No, your lordship has got the other list of dates. Sorry, my lords. This is a list of dates. It says list of dates on grounds raised qua the conduct of the arbitrators by the appellant, and that has an appendix B.
Page 1. They marked it as volume 1.
Your lordships had marked it as volume 1 by hand.
yes, we undid the marking because it was irrelevant now.
Lordship, please. Your lordship sees from paragraph 2 onwards.
Oh, this is a veritable note. When did you apply for thing? After the award?
Yes, because, my lords, our cases that we knew about, we came to know about this.
When did you come to know according to you?
Yes. If your lordship just sees page, the third date, my lords. On page 2, the fourth date, 26-27-11-2016, during the 10th reference pertaining to reference to one of the arbitrators, Mr. Kulkarni inadvertently discloses that he and the presiding arbitrator had been... Page 2, my lords. Your lordship sees the fourth entry.
During the 10th hearing?
That's correct.
In reference to
That's in reference to.
award here.
The award year had already been passed
In August?
in August.
In August and October?
That's correct. Then, in the course of the 10th hearing of reference to, one of them disclosed inadvertently that he and the presiding arbitrators had been residing at the respondent's guest house. Now, it is after that hearing that a legal notice was issued to us through the advocate for the respondent, who was also the counsel appearing in the same proceedings, on behalf of the arbitrator to withdraw certain allegations and threatening to take certain penal action if the allegations are not withdrawn. Then, my lords, over the page, 15/12/2016, we filed a petition under section 14(1)(a) in respect of reference to for appointment of another arbitral tribunal. Then, my lords,
Application
on
under
15/12,
section 14.
That's
When?
then, my lords, on 15/12/2016. This was in respect of reference to.
Two, yes.
Lordship pleases. Then 22/12/2016, there is a reply to the legal notice by the counsel pointing out the conflict of interest by engaging the same counsel as one of the parties before it to act on its behalf. 26/12/2016 is a reply to the letter by the counsel who does not deny acting on behalf of the respondent.
Ultimately resigned in June 2000.
27/2/2012, an affidavit and opposition is filed by the respondents in the section 14 proceedings, wherein it was not.
All this is done. Now, what is the reference, that case?
The Bombay High Court judgment.
61 SCC Online, Bombay 7.
Yes, that's correct.
One of the judgments were handed over last time.
There was a compilation of authorities that we'd handed over last time.
That's just the first case.
That's the
you
first.
cited.
Yes.
Next is, when did you apply under section 34?
2016.
No, what is the date?
I'll just give you a lordship the date. Where is my thing gone? Just give the date.
Exact date.
The exact date I don't have.
When was the affidavit in support of the petition verified?
Yes, Bharat.
That could be the earliest date.
Yes. Which date? When we applied under section 14. Because I'm not, I'll just verify that and I'll give your lordship the exact.
You don't have the section 34 petition here?
It has a blank.
It has a blank, Malad. So therefore,
But I have the dates.
Service copy will be there, yes.
Lord, lot 1, my lord, was filed on 20. The award was of 21st August 2016, filed on 26th October 2016.
So, lot 1,
Award is 21st August 2016. Section 34 filed on 26th October 2016. Lot 2, my lord, 21st August 2016 is the award, filed on 28th November 2016.
yes.
Lot 3, my lord, 21st August 2016 and filed on 2nd December 2016.
The two stray ones,
Yeah, my lord, both awards are of 14th October 2016. The first, my lord,
14th October.
14th October 2016. The first road, my lord, 17.6 kilometers, it was, my lord, challenged on 20th of December 2016. And the second one was 9th December 2016. Sorry, 11 days before.
Now,
No correction.
let us excuse them of the 26th October, section 34. In the 28th October, section 34, have you taken the ground of bias?
In all, we have only taken it in June 2000.
yes, in all these points, in the first time that we have taken the point of bias is in June 2019 by way of
You
an
can forget it.
amendment.
You can
application.
forget, by way of an amendment.
Yes.
In all the 34.
Yes, in these 34.
Very good.
Yes.
So, amendment to section 34 in June 2017.
19.
2019.
2019. Yes.
So, by then it's already limitation.
That's a possibility.
So we've given that date on page 5.
We've
There
given
is something else that I remember vaguely. On the last occasion, you wanted to show some bills, and we had asked you that how the arbitrators were not from Delhi, so how did you pay for their fooding and lodging, and how were those bills raised? So why would you not know, if you exercised a bit of diligence, that they were accepting the hospitality of the contractor?
Yes, I had sought instructions on that aspect. So the instructions that were given to me were this, that we never got a breakup from the arbitrators. What happened is that the arbitrators raised a consolidated bill upon the claimants. The claimants paid that amount to the arbitrators, and then thereafter they gave us that particular amount which they had paid to the arbitrator, and we thereter reimbursed
No, we
them.
haven't reimbursed.
Part we reimbursed?
No, we haven't reimbursed.
My instructions are they were not reimbursed.
But the breakup is not given.
The breakup was not given to us.
Did you ever seek a breakup?
I don't think so. I don't want to make any loose statement.
No. Because here is an issue of integrity that you raise.
Yes, that's right.
You cannot just irresponsibly do it.
Your Lordship is absolutely.
Even if it is the street beggar's reputation, he deserves to be protected.
Your Lord-
When you make it with all prejudice, and you're left scalded if we find it irresponsibly taken. We warn you, you're dealing with someone's reputation.
But
You can hit him, get him repaired. But once you target his reputation, you can't get it repaired. You're a public company, a government company. If you're irresponsible, you'll pay, you'll bleed, and we'll make you bleed.
But as
So don't take an irresponsible
Your
stand.
Your Lordship is absolutely right. As counsel, Malad, I am not in a position to press this point
Of bias.
of bias.
Very well, we'll record that.
Very well.
That authority you have as counsel.
Yes. Because I am not even looking behind to seek instruction. As counsel, Malad, I take the call.
Thank you. We must maintain some standards. Because whoever it is involved,
Your Lordship is right.
your questioning his parentage, his integrity. There you can't be responsible. He may have made a mistake that all of us do. We do it every day. But when you attack my reputation, when you attack my integrity, that's something more.
Malad, I'm extremely grateful for a patient hearing.
Thank you. Wonderfully constructed. Wonderfully constructed.
I'm extremely-
and it's absolutely to the point and excellent resistance.
Your Lordship is too kind, Malad.
No,
I'm
no.
grateful.
This is how it should be structured, Get it down to. Hey, I'm sorry it took a few harsh words from us last time, but
Never taken that. Just one point which my
the only interest is to, over here we have a lot of time. But in other commercial courts, if judges could take a grip and reduce the matters to what is really the brass tacks of the dispute, then things wouldn't take so long.
There's a collective responsibility, Malad. Sometimes, Malad, often I have noticed that the judges do try to do that, but there's a lot of resistance, Malad, because you want to argue each and every point to its hilt. So therefore, that's the challenge that is faced.
And sometimes judges also try to also enjoy taking a nap while you're rambling. Yes.
Malad, my learned junior points out one thing, and in all fairness, I must make that point. I had made a submission with regard to this tunnel collapse and deviation and rock strata, and I had relied on one clause, that is 3.10.1. I checked the pleadings, that clause, Malad, hasn't been specifically referred to by us. But clause 7 and 6.6, which has been specifically
on
on
rock strata deviation,
Yes,
and on
only on rock strata deviation.
only on rock strata deviation.
So the impact of the clause which is not referred is mirrored in the other clauses. That is 6.6 and 7.
And 7, but not specifically referred.
It's not specifically referred to in my pleadings.
6.6 is referred to in the award,
Yes. 6.6 the award refers to,
and 7 is in
and 7 is specifically referred to in my written submission.
the ones we handed over, page 17.
Very
It's at page 17 of my written
Thank
submission. I just wanted to be true to the record.
Yeah, start tomorrow, subject to. I'm great. Lord, may I just pass on the chart? We've color coded the chart for the 5 Milord contracts, which will make it easier perhaps for your Lordships, Milord, to. Because, Milord, there are overlapping claims. Lord, if your Lordship would be so kind as to have the first call, lot 1.
Yes,
Your Lordships will see there are 2 claims, one in orange and the other in yellow.
yes.
These are, my Lord, exclusive to lot 1.
No, oh, very well. The second one is in yellow. We are.
Yes. The third one, third, fourth and fifth, your Lordships will see in green color.
They are common.
Which are common, my Lord, some of them are common in.
And the blue and red are common to the 3.
That's right.
The civil works.
That's right.
Very
So
easy.
perhaps it's easy.
Just one clarification. We will only notice the judgments that you've actually cited.
Lordship.
The other ones which are part of the complaint. But you haven't educated us on arbitration law.
Lordship is educated. I think it's like carrying coal to Newcastle.
Yes. Very well. This simplifies things. Simplifies things. Thank you.
Grateful.
Grateful.
It will appear again in the supplementary list tomorrow.
Yes.
And will be taken last.
Lordship, please.
Grateful.
So you need not rush at 10:30 or 10:28.
In fact, I noticed, Manoj, that the clock here is about 2 minutes fast.
Yes.
So therefore, sometimes there's some. I remember, Manoj, once someone had mentioned to Justice Kabir, generally about the court sometimes sitting 5 minutes later. So he says, the problem is yours. He says, when I sit, it's 10:30.
But he did that in Supreme Court, did he?
But I think there are some health issues also.
Yes.
A very happy memory, Manoj, especially for the junior members of the bar.
Fine gentleman.
Yes.
Fine gentleman. Any other matter? Call them on, call them on. They won't do it. After that, you can arrange.
Second call from the main list, item number 3.